Today, we are documenting a case that did not begin with a fight. It began with a will. One name was included. One was left out. What stays with me is the calm. There were no raised voices, no dramatic scenes, just the quiet realization. To inherit the house, one person had to stop existing. And that realization was acted on. This is a case about inheritance, exclusion, and decisions made long before the crime itself. After watching, share in the comments where you think this sequence crossed the point of no return. The will was signed on October 12, 2018 in Alameda County, California. The document was notarized by a Fremont-based attorney whose records later confirmed that the signing took place without witnesses other than the attorney and the testator. The testator was Raghunath Iyer, age 74, an Indian immigrant who had lived in the United States since 1991. He died 4 years later, on May 6, 2022, at a hospice facility in Union City, after complications related to congestive heart failure. The timing of the document matters more than the death itself. The will was not a reaction. It was a decision made in advance, without urgency. Raghunath Iyer arrived in the Bay Area with a temporary work visa and remained after securing permanent residency through employment. Over 3 decades, he accumulated assets that included a single-family home in Fremont, 2 rental properties in Hayward, and several investment accounts held with U.S.-based institutions. His wife had died in India years earlier. He had 2 children, a daughter, Anvika Iyer, born in 1985, and a son, Ketan Iyer, born in 1982. Both were adults by the time the will was executed. The will named Anvika Iyer as the sole beneficiary of Raghunath's estate. The language was explicit. All real property, liquid assets, and personal effects were to pass to her upon his death. Ketan Iyer was not mentioned as a beneficiary. The document did not use disinheritance language, but it included a clause stating that any individual not named was excluded by intention. That clause would later become central. The document does not explain itself. It does not justify the choice. It only fixes it in legal form. Anvika had lived with her father since 2016 after leaving a job in San Jose to provide full-time care. Medical records showed repeated hospitalizations beginning in late 2017. Pharmacy logs, appointment schedules, and home health invoices all listed Anvika as the primary point of contact. She handled medications, transportation, and daily supervision. Her father's finances remained in his name, but Anvika was added as an authorized signer on several accounts for bill payment purposes. These records are not emotional documents. They do not describe intent. They only show repetition, over years, without interruption. Ketan's presence during this period was limited. He lived intermittently in Sacramento and Stockton, working short-term jobs and staying with friends. Court records later showed multiple alcohol-related citations between 2015 and 2021. He was not listed on any medical or financial documents related to his father's care. He visited Fremont sporadically, sometimes months apart. Absence does not require explanation when it is consistent. It only becomes relevant when contrasted with permanence. There is a tendency, in cases like this, to frame caretaking as virtue and absence as neglect. The documents do not require that framing. They only show continuity. One child was present, the other was not. The will remained unknown to Ketan for several years. According to phone records and testimony later entered into evidence, he first learned of its existence in March 2022, 2 months before his father's death. He was not told by the attorney. He was not informed by his sister. He discovered it while searching for insurance paperwork in a filing cabinet at the Fremont house during an unannounced visit. The document had not been hidden. It was placed in a labeled folder with other estate planning materials. It did not need to be concealed. It only needed to exist. A legal document does not provoke a reaction by force. It provokes one by consequence. From that moment, the structure of the family changed. The will established a future in which Ketan Iyer had no legal standing. It did not punish him. It did not accuse him. It simply removed him. Ketan did not confront his father. He did not ask for revisions. He did not seek legal advice at that stage. Instead, he began asking Anvika questions about property taxes, account balances, and the status of the rental units.
Before we dive deeper, let us know in the comments where you're watching from. We'd love to hear from you. And don't forget to hit that subscribe button so you never miss any of our upcoming videos.
Raghunath Iyer died on May 6, 2022. The death certificate was filed 3 days later. Probate proceedings had not yet begun when Ketan returned to Fremont again, this time staying longer, and positioning himself inside the house that the will had already assigned to someone else. From this point forward, the conflict no longer develops inside a family. It moves into a legal space where proximity and entitlement are not the same thing. Ketan Iyer remained in Fremont after the funeral, extending what was initially presented as a short visit. He slept in the guest room, used the kitchen, and began inserting himself into the daily routines of the house. Anvika did not object. At that point, there was no formal transfer of property, and probate had not yet been opened. The house was still legally in their father's name. Within days, Ketan began asking questions that were not connected to mourning or logistics. He asked about property tax deadlines, the status of the Hayward rentals, and whether the tenants paid by check or electronic transfer. He asked where account statements were kept and whether their father had used a financial advisor. These conversations were later reconstructed from Anvika's messages to a friend and from Ketan's own statements during questioning. The questions were not aggressive. They were methodical. They followed a sequence that suggested prior thought. At the same time, Ketan's personal situation continued to deteriorate. Employment records showed no steady income. His bank account carried a negative balance for much of April and May 2022. 2 weeks before Raghunath's death, Ketan had been cited in Stockton for public intoxication. The citation was resolved with a fine he did not immediately pay. In early June, Ketan contacted a probate attorney in Newark, California. He did not disclose the existence of a will. Instead, he asked general questions about intestate succession and the transfer of property when a beneficiary dies shortly after the testator. The attorney later confirmed that the inquiry focused on hypothetical scenarios and did not reference specific names. This point matters because it establishes sequence. The legal inquiry came before any conflict with Anvika. On June 14, 2022, Anvika scheduled an appointment with the same Fremont-based attorney who had notarized the will. The purpose was to initiate probate and retitle the Fremont house. The appointment was set for June 28th. Ketan was not informed of the date, but he became aware of it after seeing an email confirmation on Anvika's laptop, which she had left open on the dining table. From that moment, his behavior changed. According to later testimony, he began staying awake at night, pacing the backyard, and drinking more heavily. He accused Anvika of hiding documents and asked to see the will itself. When she refused, he told her that the document could be contested and that nothing was final yet. A will can be challenged in court. That process is slow, uncertain, and expensive. It requires evidence of incapacity or coercion. None of that was present here. What was present was a simpler legal path. If Anvika died before the estate was settled and without a will of her own, the assets would not remain in limbo. They would pass to the next surviving heir. On June 19th, Ketan asked Anvika whether she had ever written a will. She said no. She told him she had planned to do it after probate was completed. That answer would later be confirmed by her attorney. This was the moment when the situation stopped being reversible. From that point forward, every option available to Ketan involved delay, loss, or exclusion. Contesting the will offered no guarantee. Leaving Fremont meant surrendering proximity. Waiting meant watching the property transfer out of reach. The remaining option did not require documents or courts. It required access. On the evening of June 22, 2022, Ketan suggested they review their father's paperwork together and sort out what could be discarded. He brought alcohol into the living room and positioned the folders on the coffee table. Anvika agreed, believing the discussion was about closure rather than control. The conversation did not escalate into a loud argument. Neighbors later reported hearing nothing unusual. What followed occurred inside a closed house, after midnight, without witnesses. Anvika Iyer did not show up for work the following morning. Her phone went unanswered. Her car remained in the driveway. Ketan stayed inside the house. June 23, 2022, passed without incident at the Fremont house. No calls were placed to emergency services. No reports were filed. The front door remained closed. The car stayed parked on the residential street where it had been left the night before. From the outside, there was no visible disruption. Inside the house, Ketan Iyer remained alone. Phone records show that he used Anvika's phone briefly that morning, accessing messaging applications without sending replies. Her employer attempted contact multiple times. No response was received. By the afternoon, her supervisor documented the absence as uncharacteristic and escalated the issue internally. Ketan did not contact her workplace. He did not notify extended family. He did not report her missing. Instead, he began handling practical matters. Grocery receipts show short trips to a nearby market. Utility usage remained steady. Internet activity logs later recovered from the home router showed searches related to probate timelines, beneficiary rights, and the process for managing property when an owner is unavailable. These searches were conducted under Ketan's personal user profile. This sequence matters. Administrative preparation began before any external inquiry. In the early evening, Ketan contacted the probate attorney he had previously consulted. He described Anvika as temporarily unreachable and asked whether property maintenance and rental income could be managed by a sibling in her absence. The attorney advised that no authority existed without formal documentation and suggested contacting law enforcement if there was concern for her safety. Ketan did not follow that advice. There is a pattern that appears in many disappearance cases. The person closest to the missing individual often delays reporting, believing the situation will resolve itself. That explanation does not apply here. Ketan was not waiting for contact. He was preparing for outcomes. On June 24th, Anvika missed a second day of work. Her supervisor attempted contact again, then reached out to one of her emergency contacts, a coworker listed in internal records. The coworker had not heard from her and went to the Fremont house that afternoon. No one answered the door. Later that evening, the coworker contacted Fremont police to request a welfare check. Officers arrived shortly after 9 p.m. They knocked. Ketan answered. He told them his sister had gone away for a few days and had not shared details. He declined entry, stating there was no reason for concern. At that stage, officers had no legal basis to force access. The car was not reported stolen. There were no signs of distress visible from outside. The encounter was logged as informational. After the officers left, Ketan sent a message to Anvika's supervisor stating that she was taking personal time and would be unavailable. The message was brief and unspecific. It conflicted with her employment history, which showed no unannounced absences longer than a single day. Absence can be explained once. It becomes evidence when it requires maintenance. Over the next 48 hours, Ketan's actions remained consistent. He stayed at the house. He accessed Anvika's laptop and attempted to log in to financial accounts. He did not successfully move funds, but metadata later showed repeated attempts. He also reviewed scanned copies of property documents stored on the device. On June 26, he contacted a second attorney, asking about the process for managing assets when a beneficiary cannot be located. The inquiry again avoided specific names or circumstances. The attorney advised that missing person status did not transfer ownership and that any action would require court involvement. By June 27th, concern had extended beyond the workplace. Anvika's co-worker returned to the Fremont house and found it unchanged. The car remained where it had been parked. Mail accumulated in the box. No one responded from inside. At 9:12 a.m. on June 28, 2022, the co-worker formally reported Anvika Iyer missing to the Fremont Police Department. The report shifted the situation from private explanation to public record. Once that threshold is crossed, control over the narrative no longer belongs to the person who remains inside the house. Investigators were assigned that afternoon. The first step was procedural: verify last contact, establish a timeline, and attempt direct outreach. Calls to Anvika's phone went unanswered. A ping request was prepared. Officers scheduled a follow-up visit to the Fremont residence. That visit would not be a welfare check. It would be the beginning of an investigation. Investigators returned to the Fremont house on the morning of June 29, 2022, after the missing person report had been formally logged. The change in status allowed a documented welfare check connected to an active investigation. Ketan Iyer answered the door and permitted entry. Inside, the house appeared controlled rather than disturbed. Furniture was in place. There were no signs of forced entry and no visible damage. Anvika's personal items were absent from common areas. Her purse was not visible. Her phone charger was unplugged. The living room table was clear. Order, in this context, did not suggest calm. It suggested intervention. Ketan told officers that his sister had left voluntarily after a disagreement and had not said where she was going. He stated that her car remained at the house. The statement was documented without challenge. Investigators began assembling an external timeline. Neighboring residences were canvassed for security cameras. Footage from across the street showed Anvika's car leaving the driveway at approximately 6:40 a.m. on June 23rd. The vehicle returned several minutes later and was driven directly into the garage, where it remained out of view. That movement marked the first deviation from routine. Additional footage from a side street camera showed the same vehicle exiting the garage entrance just after 2 a.m. on June 24. This time, it did not return immediately. The car came back shortly before dawn and was parked again on the driveway, positioned as it had been previously. The pattern was inconsistent with normal use. It was consistent with staging. When investigators inspected the vehicle later that day, it showed no exterior damage. The interior, however, told a different story. Luminol testing revealed trace blood residue in the rear cargo area and along the edge of the back seat. The stains had been partially cleaned, but not eliminated. Fiber fragments consistent with clothing were recovered from the upholstery. The vehicle was towed for full forensic processing. Investigators requested Anvika's phone and laptop. Ketan stated he did not know their location. Both devices were later found inside the house, powered off. Digital analysis showed login attempts after Anvika's last confirmed activity. The timing did not align with her alleged departure. At this stage, absence was no longer the central issue. Movement was. Investigators expanded the scope of the inquiry outward. Traffic cameras were reviewed along routes leading away from Fremont during the early morning hours of June 24th. One sequence, captured near the Darbenton Bridge toll approach, showed Anvika's vehicle traveling eastbound toward Alameda County. The timestamp aligned with the second departure from the garage. This narrowed the search area. Investigators contacted regional park authorities and reviewed access logs for public shoreline areas along the eastern edge of the bay. One location, a remote service road near the Newark Slough, showed vehicle activity during restricted hours, but no corresponding permit records. The location did not attract attention by itself. What made it relevant was timing. On July 1st, investigators transported Kedden Iyer to the police department for formal questioning. The interview was recorded and conducted under standard missing person protocol. At that point, no arrest had been made. Keaton denied any involvement in his sister's disappearance. He stated that Anvika had left the house voluntarily after an argument and had not disclosed her destination. He denied driving her vehicle during the early morning hours of June 24th and claimed he had remained at home throughout the night. When asked about the vehicle movements documented on nearby cameras, he said the footage must have captured routine activity from an earlier date. His account was internally consistent but not supported by external records. While the interview was ongoing, investigators executed a search warrant on the Fremont house. The scope included common living areas, personal electronics, and surfaces with potential trace evidence. No signs of forced entry or visible struggle were documented. Cleaning agents were found in the kitchen and living room, consistent with routine household use. Trace examination later identified diluted biological residue on the living room floor and on a section of the coffee table base. The quantity was minimal. The medical examiner would later explain that asphyxiation can result in minor bleeding from the nose or mouth due to capillary rupture, particularly when pressure is applied to the neck. Such bleeding does not indicate a violent struggle and can be transferred during movement. The absence of overt disturbance inside the house did not exclude the possibility of homicide. It narrowed the manner in which it occurred. Investigators then turned outward. Based on reconstructed vehicle movements and traffic camera analysis, search efforts were directed toward shoreline access routes east of Fremont. The focus was placed on areas reachable within a short driving window and offering concealment rather than isolation. Search teams were deployed to the Newark Slough area on the morning of July 2, 2022. The location consisted of maintenance corridors and service roads not regularly monitored during nighttime hours. Access points were limited and unmarked. Within hours, search personnel identified disturbed vegetation near the waterline. The ground showed compression inconsistent with foot traffic alone. Drag marks were visible along a shallow embankment, terminating near dense reeds. The pattern suggested recent placement. At approximately 11:40 a.m., a human body was located partially concealed near the shoreline. The remains were identified later that day as Anvika Iyer. The position of the body and surrounding conditions indicated that the site had been used for concealment rather than as the location of death. A forensic examination determined the cause of death to be asphyxiation caused by external pressure applied to the neck. There were no defensive injuries. The findings were consistent with a close contact act occurring indoors. Physical evidence recovered from the scene was compared with materials collected earlier. Soil samples matched particulate matter recovered from the rear cargo area of Anvika's vehicle. Fiber fragments consisted with her clothing were also recovered. Trace blood residue found in the vehicle was consistent with secondary transfer during transport rather than an injury sustained inside the car. These findings established a continuous chain between the house, the vehicle, and the recovery site. Ketan Iyer was interviewed again that evening. He was informed that Anvika's body had been recovered and that forensic evidence linked the vehicle to the location. He was also informed that biological residue consistent with post-mortem transfer had been identified. During the second interview, Ketan altered his account. He acknowledged driving the vehicle during the early morning hours of June 24th and transporting his sister's body to the Newark Slough area. He stated that he believed the location would delay discovery. He did not dispute the cause of death. The statement confirmed the sequence already established through independent evidence. Ketan Iyer was formally arrested that night and charged with second-degree murder, concealment of a human body, and obstruction-related offenses. From that point forward, the investigation concluded. What remained was adjudication. Formal charges against Ketan Iyer were filed in Alameda County Superior Court on July 5, 2022. The prosecution proceeded under a theory of second-degree murder, with additional counts for concealment of a human body and obstruction-related offenses. From the outset, the case was framed not around a sudden act of violence, but around a sequence of decisions set in motion weeks earlier. Pre-trial hearings focused on admissibility of evidence. The defense moved to suppress the vehicle search, portions of the digital analysis, and the recorded interviews. The court denied the motions. Warrants were found valid, forensic handling compliant, and the second interview admissible after proper advisement of rights. At trial, the prosecution organized its presentation around causality rather than character. Jurors were shown a timeline that began before the death of Raghunath Iyer. The will, signed in 2018, was introduced not as a background detail, but as the initiating document. Testimony established that the estate transferred entirely to Anvika Iyer and that no provision existed for Ketan. Probate experts explained that if Anvika died before final settlement and without a will, Ketan would become the next legal heir. This legal structure was central to the state's argument. Witnesses testified that Ketan learned of the will shortly before his father's death, made early inquiries about inheritance law, and returned to the Fremont house despite having no ownership interest. Financial records showed instability. Legal inquiries showed anticipation. The prosecution argued that by mid-June, the options available to Ketan had narrowed to three: contest the will with no evidence, leave and lose access, or remove the sole beneficiary. The case presented did not suggest a spontaneous escalation. It described an elimination of alternatives. Investigators testified to Ketan's actions after Anvika's disappearance. The failure to report her missing, the use of her phone and laptop, the staged vehicle movements, and the transport of her body. Forensic experts explained how minor biological transfer can occur during post-mortem handling, consistent with asphyxiation and subsequent movement. Traffic camera analysts traced the route to the recovery site. Each element was presented as part of a single, continuous sequence. The defense conceded the death, but challenged intent. Counsel argued that the confrontation was unplanned and that Ketan acted out of fear after the fact. The prosecution responded by returning to timing. The will predated the crime. The legal inquiries predated the disappearance. The vehicle movements were staggered. The concealment was deliberate. Fear, the state argued, does not require preparation. In closing arguments, the prosecution avoided moral language. It focused on structure. A document excluded one heir. That exclusion created urgency. Urgency combined with access produced action. The killing, the state argued, was not about rage. It was about inheritance. Jurors were instructed to consider whether the evidence demonstrated knowing conduct tied to a clear objective. Deliberations lasted 2 days. On November 18, 2023, the jury returned guilty verdicts on all counts. At sentencing, the court addressed motive directly. The judge noted that the homicide was committed to remove a legal barrier to property, not in response to provocation. While the defendant had no prior violent convictions, the court emphasized the calculated nature of the concealment and the use of the victim's vehicle to carry out the plan. Keaton Iyer was sentenced to 27 years to life for second-degree murder, with consecutive terms for concealment and obstruction to be served in state prison. Parole eligibility was set by statute. The court did not describe the case as tragic or senseless. It described it as preventable. The record showed a progression from exclusion on paper to control in practice, ending when one person decided that inheritance required absence.